Standpoint. Good afternoon, everyone, and thank you so much for joining us today on this beautiful day of winter. My name is Ana Maria Studer. I'm the Advocacy Support Program Manager here at Standpoint. I'm repeating because we were not recording before. This webinar is being recorded, so you know, and the link to the recording is going to be emailed to our Standpoint Legal Advocates listserv, and it's going to be added to our YouTube channel and website later on. Also, I'm going to post the link of the PowerPoint in our chat box, so it's going to be easier for all of you to follow along. Most of you probably already know about our organization, but for those that listen to this later or that doesn't know about it, Standpoint is a statewide organization. We are a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to system professionals who work with survivors. And we do this by facilitating trainings and answering calls through our action line. Examples of the trainings that we do is the new laws training that we do every year throughout the state of Minnesota, the monthly webinars for advocates like the one that we're going to be presenting today, and other trainings by request. Our action line is answered Monday to Friday from 9 a.m. to 4 p.m. And it is through that action line that our attorneys provide legal advice to survivors, and our advocates connect callers with resources. We do safety plannings, and we listen and help callers identify possible options and next steps. Today's webinar is advocating for domestic violence victim survivors within the criminal justice system. And the presenters are Maddie Nelson, one of our legal advocates, and myself. So now I'll hand it to Maddie to get us started.
All right. Hey, everybody. Welcome. Well, thanks for getting us started there, Ana Maria. My name is Maddie, and as Ana Maria just said, we will be discussing advocating for domestic violence victim survivors within the criminal justice system, which is a bit of a mouthful, I know. And of course, this is an enormous topic. We aren't going to be able to cover everything, but our objective is to go through some of the most crucial information and strategies needed to do this work. And we've organized it in a way that goes somewhat in order of how the system works. So starting with common criminal offenses, how they work, what law enforcement's timeline is, and some opportunities for advocacy at that stage. And then we're going to transition into how the court process plays out and some of the most significant advocacy considerations throughout that. Towards the end, we're going to cover victim rights and why using a victim-centered approach in providing advocacy is just really important here. And I want to mention that usually Standpoint uses the term victim survivor to represent the spectrum in which someone might identify. But here and there throughout this presentation, you may hear us just use the term victim. And that is because we're going to be using it within the context of the criminal justice system, where that term has a little bit more of a precise legal definition. And then we want to know what your questions are throughout the presentation. We're going to do our best to answer them as we go along here. We do have our wonderful coworker and fellow legal advocate, Raylene, on with us to help with them. So you might get your answer from her through a message reply, or Ana Maria or I might try to answer them as well. But please utilize the Q&A box rather than the chat so we can stay organized. Okay. So let's jump into it. We'll begin by looking at the crime of domestic assault. This is probably the most common one you're dealing with, and so we'll break it down just a little bit. So there are two ways to commit domestic assault in Minnesota. Whoever does one of the following against a family or household member is guilty of it. So that is commits an act with intent to cause fear in another of immediate bodily harm or death, or intentionally inflicts or attempts to inflict bodily harm upon another. And you may see these referred to as fear-based or harm-based domestic assault. And there are a couple of important pieces of this statute to understand. The first one is what constitutes a family or household member. And this is a very broad definition. It includes spouses or former spouses, parents and children, people related by blood, people who are presently residing together or who have ever resided together in the past. So that would catch roommates, people who have a child in common, regardless of if they've been married or have lived together at any time. A man and a woman, if the woman is pregnant and the man is alleged to be the father, regardless of whether they have been married or have ever lived together at any time, or persons involved in a significant romantic or sexual relationship. And aside from the line identifying a pregnancy between a man and a woman, these relationships are genderless. So this definition does a pretty good job of capturing all the relationships that we need it to. The second piece is that in order to commit this crime, you have to have intent. And you don't necessarily have to mean to cause the level of harm that occurs, but you do have to have intent to cause some fear or cause some bodily harm. So you can't charge someone who accidentally hurt someone. And of course, you'll see people claiming that as a defense. But when a prosecutor is charging this crime, they have to prove all of the elements here beyond a reasonable doubt. And the other thing to know about this crime, and really most others associated with harm caused between people who fit within that definition, is that unlike non-domestic assault, once law enforcement has established probable cause, they must charge it. The state takes over at that point, and it is not the victim's choice whether or not it gets charged, which is a common misunderstanding. And the reason for this is, of course, because it takes some of the responsibility off of the victim and considers that they might be too intimidated or fearing retaliation if they go on record making that choice to press charges. But a lot of people don't know this. They see in the movies people being asked if they want to press charges. They think that they can report an assault just to get it on the record, and then are surprised when they're told that the offender is going to get charged. And they might feel that this is going to make them even less safe, especially if it catches them off guard like that. So as advocates, it's really our job to make sure that that is understood. So here we have some of the other crimes that we often see offenders charged with. We don't have time to get into the statutes for each of these, but we include them to stress that advocates should be very familiar with not just what they say, but what your particular prosecutors and thus law enforcement are looking for in the way of probable cause for each of these. And Anna Maria is going to break down probable cause in a bit, so I'm not going to say too much about it, but really it's about obtaining an amount of evidence that gives them some confidence that they're going to be able to get a conviction. So they can believe strongly that one of these crimes occurred based on things like offenders' past behavior or their circumstances. But without enough evidence, they're wasting their time charging it. And more importantly, they're violating that person's civil rights. But many of us read police reports and may have noticed that sometimes things get missed. Maybe you read what sounds like good evidence of one of these crimes occurring, but you don't see it charged. Maybe the victim hints at something, but the responding officer didn't ask follow-up questions. And in the meantime, you're working with someone who's telling you that they don't understand why the incident isn't being taken more seriously. So how can we advocate for them in these situations? Many of us, most of us, have not been to law school. We haven't been to the police academy, but we can read these statutes. And if we understand them well, we can catch important details and ask law enforcement questions to make our point. So for example, maybe you read a police report that quotes a threat that the offender made during a domestic assault that is very specific, and you think based on your knowledge of the statute that it rises to the level of felony threats of violence, but you see that they weren't charged with it. So can you call your investigator, statute in hand, and just ask them to explain why that quote doesn't fit within it? Maybe see if they're willing to discuss their interpretation of the statute with you. Sometimes just doing that points out an angle of it that they hadn't considered. But the more we understand these statutes and the evidence prosecutors are looking for, the greater ability we have to question police responses when that's needed. All right, so next let's talk about enhancements on domestic assault and order violations. And I'm going to back up just for a moment to explain that criminal statutes in every state have multiple categories of criminal offenses. We probably all know this. They include felonies, misdemeanors, and infractions usually. In Minnesota, we classify our misdemeanors into the categories of petty, regular, and gross. but in many states, you might hear them referred to as class A, B, C, or class 1, 2, 3 misdemeanors. But lawmakers determine the category of a particular offense based on factors like severity, the circumstances in which it took place, and the damage it caused. And of course, the higher the offense, the higher the penalty. Pretty basic stuff, but just to make sure we're all on the same page. So some offenses that start out at that misdemeanor level are enhanceable to more serious levels if the offense is repeated. And domestic assault and OFP, HRO, and DANCO violations are like this. So the way it works in Minnesota is if it's your first offense, it's going to be charged as a misdemeanor. If, however, you have one previous conviction on any of these, a new charge would be a gross misdemeanor. If you have two convictions, the new charge would be a felony. Two or more convictions, I should say, the new charge would be a felony. And then other violent crimes like strangulation, threats of violence, convictions on those in the last 10 years would also enhance these. And in my experience, teaching myself how this works as an advocate without any formal training or law school experience was a little confusing because it butts up against some system realities that were surprising to me. And what I had to keep reminding myself of was the key here is that it needs to be a conviction before it can be used to enhance. So for example, I would see an offender charged with a misdemeanor domestic or some type of order violation at that regular misdemeanor level, and it would feel like a mistake. Like it should be a higher level because I knew their name very well. I knew that they frequented the criminal justice system for these types of crimes. Maybe I was hearing from my clients specifically what they were doing. And I would open up MinSys or MCRO to look at their history and see multiple charges within this family of crimes. I think I saw one person once with like 16 different charges for domestic assault related crimes within the last 2 years. And all of the domestic assaults and OFP violations were still just at that misdemeanor level because they were all still just pending. The offender hadn't been convicted on any of them, so there was nothing to enhance future offenses. And that's really frustrating when we see that. It's frustrating for advocates, and we know it is incredibly invalidating and scary for victim survivors to have someone be able to just keep violating you without what feels like a proportionate system response. And as an advocate, my brain is not always focused on innocent until proven guilty. I'm not coming at it from that perspective, and neither are victim survivors for obvious reasons. But the problem isn't that people have civil rights. The problem is that the courts are extremely overloaded and they move very slowly. And so you see this a lot, where the intent of these statutes sort of get watered down by the reality of what it takes to enforce them. And I know I'm starting to get kind of high-level philosophical here, but this is the space that advocacy exists in and where we try to make a difference. So what strategies exist to encourage the system to work faster or more strategically so that new offenses can be recognized at the appropriate level? And on this slide, we have some. And the first one is to point out excessive pending charges to your prosecutors. If all of the charges are being handled by one office, they're probably very aware of what's going on. However, many places have both a county and a city prosecutor's office, and the offender may have charges pending in both. So don't assume that these offices are communicating and noticing what's going on in the other one. I've definitely seen this overlooked. And then I'm also sure that I don't have to tell many of you that small geographical areas may be covered by several counties. And so you might have charges in all of them. And it's not that these different offices are all going to be able to strategize together, but it may be useful or motivating for them to be reminded of what this person is up to in other areas. And then the next one here is to keep an eye on accepted guilty pleas on pending charges. So there's a period of time between when a defendant pleads guilty and the judge accepts it, and when that sentence is ordered and the case turns into a conviction in the system. This accepted guilty plea should be able to be used to enhance future charges, but it's something that's missed a lot, especially if the accepted guilty plea is in another county. So if you have the time to click on these charges and see what's going on, you might find some helpful things to point out to your investigators or prosecutors. And then the last one here is to consider if the offender has convictions in other states. So if you're working with someone who tells you that they used to live in Tennessee and we're dealing with abuse there as well, ask if the abuser was ever arrested for it. Criminal convictions for these crimes from other states can often be used to enhance the level of a new charge in Minnesota. So some good things to check for. All right. We're going to move on from criminal offenses and more into processes in a moment. But before we do that, we're going to take a look at the levels of bodily harm and how that affects charges. And maybe I want to pause here for just a moment to see if we have any questions.
Nope, you're doing good.
Okay, thank you. I just saw 9 notifications in the chat, so I wanted to make sure. All right, so the crime of harm-based domestic assault requires only that this top definition of bodily harm has occurred. So that is physical pain or injury, illness, or any impairment of physical condition. So really, this is a spectrum that starts at any indication of bodily harm, so a red mark, a tiny scratch, but it covers any other amount of injuries up until this next definition, which is substantial bodily harm. So that is injury which involves a temporary but substantial disfigurement or a temporary but substantial loss or impairment of the function of any bodily member or organ, or a fracture of any bodily member. And then this would be 3rd-degree assault. Great bodily harm is the standard for which 1st-degree assault is charged. So that is injury which creates a high probability of death or a serious permanent disfigurement or a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily harm. So the most serious type of assault. And it's really good to have some familiarity with these differences, because oftentimes people don't learn the extent of their injuries until after the assault has been charged. And so law enforcement won't have that information unless the victim, unless they do additional follow-up with the victim or they report it. And that's where advocacy can play a role in assisting them with providing additional evidence to law enforcement. So for example, medical records that state what the final diagnosis was are going to be pretty essential for a higher degree assault to be charged. So assisting them with getting that evidence in. And a tip on that would be that if the injuries are suspected to be more severe than what can be immediately assessed, and the victim is telling you that they're planning to go to the hospital, it's a good idea to ask them if they want to sign a release of information for the police while they're still at the hospital. And then let the police know that those records will be waiting for them so they can go pick them up, rather than trying to organize that after they've already left. And many officers are going to encourage that anyway, but they don't always know if someone goes to the hospital, so it can be very helpful for advocates to make that happen. And there would be considerations around how long to sign the release for, so you'd want to keep that in mind and discuss it with them as well. Okay, and now I'm going to hand it over to you, Anna Maria.
All right, so now we're going to talk about probable cause and evidence that they can use or law enforcement can use as probable cause. So what happens after a person has been assaulted? The victim has the option to call 911 during the assault, meet with law enforcement a few days after the assault, or maybe they decided to not make a report at all and ended up calling some of us, calling to a domestic violence program, wanted to talk to an advocate, right? In Minnesota, an officer may arrest someone without a warrant when probable cause exists to believe that the defendant committed a crime within the past 72 hours. One of the most commonly investigated and charged domestic violence crimes is domestic assault. And as Maddie said, assault, threats with a dangerous weapon, fear of immediate bodily harm to any person covered by the family or household member definition. So what is exactly probable cause? Is when a police officer has a reasonable grounds to believe that a crime has been committed, is founded on specific facts or circumstances supporting the suspicion of the criminal activity. A police officer must have more than a subjective hunch to make an arrest or get an arrest warrant. They need to have objective evidence that indicates the suspect's responsibility for the crime. The evidence that they normally use to prove probable cause during domestics is the condition of the clothing, property damage, punch on the walls, breaking things in the house, evidence of physical injuries in the victim, including either bruises or red marks, cuts, lacerations. Sometimes signs of strangulation don't have the bruising or the net marks that people are used to see, but they have the raspy voice, they have bloodshot eyes, they feel lightheaded, they have difficulty swallowing, for example. They also use the statements of the victim, of the witnesses, if there were any, and the person accused of committing the crime. They try to read the demeanor of the victim. Sometimes the victims may be quiet, they may be reserved, they appear reluctant to answer questions. Sometimes they're in denial, that they refuse to acknowledge that abuse incident occurred, they minimize the level of abuse, they could recount the account that they were telling the police, they can deny the allegations, and they don't want any further investigation, like Mari said before. And most of the time is because they want to defend the suspect. It can be a reaction to protect the perpetrator, who may be someone, they care about, they love, they are related to. Anger, victims may appear very upset, either with the suspect or with the police officer, because maybe they have been repeatedly calling the police before and nothing have happened, not arrests have been made. Some victims can be laughing. They can be saying jokes, and this might feel uncomfortable or could be misinterpreted as a sign that nothing is wrong, but really, sometimes that is a normal trauma response. So we need to know all this. Sometimes the victims may have a flat effect, like they don't show anything, any emotion, and it's also a response to trauma. Can be taken as an indication that nothing happened. Victims may be afraid of retaliation because they call the police, or maybe they are scared that the officers are not going to take any actions to stop the violence. They may be maybe have fear that they believe the police are not going to believe them. Sometimes, it happened a lot with immigrants, that they think that if they call the police, the children might be taken away. So they have that fear. They may be afraid of law enforcement because of past experiences that they have had when they have contact with the police, or with immigrants, with law enforcement in the country of origins that are completely different of what they experience here. Other evidence that they can use to determine probable cause are medical records, like we say, including victim statements to, let's say, paramedics, if the ambulance was called. They can use recorded videos, recorded interviews of witnesses, including children, if the children were present during the assault. They can use evidence of any prior domestic abuse, related convictions, existing order for protections, harassment orders, any DANCOs are in place. And if the incident happened in a public place, they can also use a videotape or a video recording that sometimes you can see in gas stations or parking lots. So we need to be aware of all these things that sometimes might not come in place when incidents happen. Now, we're going to talk now about possible outcomes and safety considerations when calling law enforcement. Is the next one. So when there is a consideration by law enforcement that probable cause exists, the suspect should be arrested. By the way, law enforcement should never ask the victim if they want the abuser to be arrested. When working with a victim survivor, we as advocates need to let them know also that law enforcement is not going to come to the home just to reprimand the abuser, to break a fight, or to tell the abuser to stop drinking. It doesn't work that way. And if they find that there's probable cause, the suspect will be arrested. I've heard from many victims that they are not aware of how the law works in this country or even in this state, that they didn't want an arrest to happen. They don't want to press charges when it's already too late. If the officer finds probable cause to believe a domestic abuse offense has been committed and intends to arrest, but the victim requests no arrest or prosecution, the officer should let the victim know that the decision to arrest is the officer's, and the decision to prosecute lies in the prosecutor. A lot of people, like Maddie said before, are not aware of this. The prosecutor may take the victim's unwillingness or refusal to testify into account, but at the end, the prosecutor can pursue the case even if the victim objects. Law enforcement should also provide the victim with information of the local domestic abuse program, and also should contact the program by phone on all arrests and provide us with information of the victim and probably a brief account of what happened. We need to get in contact with the victim to explain the situation, what is going to happen if that person is being arrested and going to court. We need to let the victim know what a DANCO is and might be part of the conditions of release, and also the consequences of violating the DANCO and how to report the violations. I'm going to talk a little bit more in depth about DANCOs a little bit ahead. Lack of probable cause means no arrest will be made. The officer also should explain the victim the reasons why the arrest is not going to happen, and also facilitate contact with the local domestic violence service provider for information regarding services. Unfortunately, we all heard stories about officers that keep telling the abuser or partner, just take a walk around the block, pull off. But we also have officers that call our organization to let advocates know that even though there is not arrest, they have concerns about the victim's safety. And we as advocates should call these victims as soon as possible and ask them if they feel safe staying at home, or if they want to come to a shelter. Let them know what a domestic violence shelter can provide for them and their children, and what a domestic violence shelter is all about. Do we need to do a safety planning with this victim? We also should give them information about order for protection and ask them if they would like to schedule an appointment with us. Those are things that have to come in mind when we get those calls. Something that can happen too is dual arrests. Even though it's very discouraged in the law enforcement world, we see it happen once in a while. So we know that many batterers describe themselves as the victims in the relationship, and that's the story that they're gonna tell the police officer. I remember clients telling me that they did call the police, but because they defended themselves, both had marks, and the officer just said, well, either you both come with me and you're both under arrest, or none of you. And what happened is, like, the victim stayed with the abuser in the house. In these cases, the officer shall determine whether there is sufficient evidence to conclude that one of the parties is the predominant aggressor based on some criteria and the officer's judgment, like actions taken in self-defense or to protect oneself. Sometimes they can see scratches in the face. They can see bite marks in the hands and the arms because somebody's trying to get the other person on top of them. If there's history of domestic violence perpetrated by one party against the other. Have the police been called to that address before? The extent of the injuries that have been inflicted. Other thing to take in consideration that is very important to know is sometimes after an arrest happened and the suspect goes to jail, we hear victims telling us that nothing really happened, that they made everything up because they were upset, that they wanted their partner to be in trouble. I remember people calling, victims calling saying, oh, I checked his phone and I saw pictures, or I saw text from another person and I got really upset. We know that most of the time this is not what really happened, but victims feel remorse. They feel guilty from calling the police and getting their partner in trouble. Maybe they're being intimidated by the abuser calling them from jail, or the abuser family. Sometimes it happened a lot with immigrant victims that they just threaten to do harm to their kids that are staying in the country behind. Or the family called them saying, hey, if you don't do this, we're gonna do this to you. So they try to do everything they can to get the charges dismissed. There is also the fear of retaliation, like I said, and all these questions come into their mind. Victims that want to recant a statement to police are taking the risk of being charged with a false report of a crime. And the first time is a misdemeanor. We need to let our victim survivors know about the consequences of changing the story to protect the abuser. Even if they don't get charged with a crime, it can affect too their credibility in the future. And if something else happened and they call the police, maybe the police are not going to believe them this time. So it's for their own safety. Now Mari's going to talk about opportunities and considerations for advocates.
I suppose I should make sure I'm off mute. Okay. All right. So Anna Maria just went into some of the ways that a call to 911 can shake out, but oftentimes victim survivors come to their advocates and tell them that they were just assaulted, but they haven't reported it yet and want to. And there are a number of ways that advocacy plays a role in this initial reporting process and some important considerations. And the first may be to actually be present with your client when they make that report. A lot of victim survivors may be afraid or not trust the police. And so it may be helpful for them to have someone there to witness the reporting process and make them feel supported. But it's really important when helping people prepare themselves for this, and if you're going to be present for that interview, that you're not inserting yourself into the investigation. You're not coaching them on what to say. And you can help them identify what information would be useful to provide, but you have to be careful not to put words in their mouth or report details for them on the record. That can complicate or even sabotage an investigation. And it's often why you hear law enforcement ask questions in a certain way. They don't want to be accused by a defense attorney of leading a victim into saying something. So if you're in the room for a report, your role is generally limited to meeting your client's most basic needs as they go through that process. So maybe you ask the officers questions for your clients after the interview is concluded, but this isn't a place to get involved with what's being reported. And then another piece here to be mindful of is to never provide photos that you took as an advocate of the person's injuries. What this does is that it makes you a party to the case. And now, in order to establish where the photos came from, you may need to testify. And police don't always factor this in, and in my experience, will happily accept existing photo evidence without considering who took them. So just remember, police should always be taking their own photos or getting them directly from the victim. But helping your client identify what photos or other evidence they might have would be useful. Maybe they have a text message from the offender apologizing for assaulting them. I've worked with so many people who didn't realize that this was useful information for the investigation. And then another opportunity for advocacy here is identifying and communicating safety concerns. So for example, maybe the police indicate after a report is made that they want to question the offender's mother. But we're not so sure that that's going to give them the eyewitness evidence that they're looking for to establish probable cause. And in doing so, they're telling the mother of the offender that they're being investigated. Our client might know that mom is going to turn around and call the offender, but the client might be under the assumption that the offender is going to be arrested and they're going to have protection, so it's not a big deal. And the police might not be considering that mom is going to warn them that the police are coming. So if we smell something like this going on, it can be very helpful to facilitate communication between the police and your client about it. All right. So most misdemeanor crimes in Minnesota, unless they are committed in the presence of law enforcement, are simply charged by citation and do not result in a warrant or arrest requirement. But as Anna Maria mentioned, misdemeanor domestic assault is an exception to this that allows for law enforcement who has probable cause to make a warrantless arrest up to 72 hours after the incident. And that 72 hours excludes the day probable cause was established. And this timeline is important for advocates to understand so that we can be preparing the person we're working with for the different possibilities here. Probably more often than not, when people are assaulted, they call 911 and the offender is arrested on scene. But oftentimes the offender flees and so is gone on arrival, or the victim simply waits to report the assault like we just discussed. And that's when this timeline comes into play, and where safety mechanisms like a DANCO can get very, very delayed. Because if that 72 hours expires and no arrest is made, they're simply going to be charged by citation. And that's going to get mailed to their last known address. In that citation, they're going to have instructions for setting up a court date for their first appearance. But the court date might be a month or more out. And then if the offender doesn't set up that court date and they miss it for whatever reason, or rather they just don't set it up, then one's going to be set for them. If they miss the court date, then a warrant will be issued for their arrest. So it's very important to be considering how delayed this process might become, because a DANCO isn't going to be put in place until an offender is in front of the judge. And of course, there are other safety considerations around this too. So it's something to keep in mind, especially if you're helping someone report an assault after it's occurred, and there is a question on whether or not the offender is going to be able to be easily located within these time limitations. Certainly, you're going to need to do some safety planning in that situation, and it might be another reason to file an order for protection if you think that DANCO is going to be delayed. It might be having a conversation with your client about that window and encouraging them to help law enforcement with locating the offender before that 72 hours expires. So, having them call 911 if they come home again, or if they find out where they're staying, maybe letting law enforcement know that. And they might have different opinions about what they want here and what's safest for them, but educating them on the possibilities is important, so that they can have as much control as possible. And just to note that probable cause for felonies is going to result in a warrant. So this is not an issue with higher level offenses. All right, so now I'm going to hand it back over to Anna Maria, and we are going to transition more into the court side of the criminal justice process.
Maddie, just an FYI, there are a couple of questions as well. I don't know if you wanted to address them or we wanted to wait.
Let's take a look. So the first one I see here, any pointers if your local law enforcement agencies refuse to share victim survivor contact information with advocates? It's a good question. Of course, you know what we're going to say about relationships. I'm not sure if there is anything statutorily that states they need to. I'm gonna direct you to call us about that so that we can do a little bit more digging on that one. I'm not super confident in answering that one here. And then the next one, if you are a bilingual advocate assisting a non-English speaking victim during a report to the police, should there be an interpreter involved in this meeting, or is it appropriate for the advocate to interpret the information provided to the police?
I can answer that.
Yeah. Yep.
If you have the police officer doing the interview, the police should be providing the interpreter. If you are bilingual, you shouldn't be interpreting for law enforcement during an interview. And I know sometimes that happens.
Okay, and then the last one we have here is, I thought that introducing a photo into evidence doesn't need testimony about who took it. The foundational question is whether it's true and accurate depiction of what it purports to be. Has that rule been changed? And I can't speak to that specific rule. That has come from stories of advocates being subpoenaed about things like that. So I think that that would be a good question to discuss with one of our attorneys. But generally, that was always the guidance that we received, was to not be providing your own photos. And I will say that I had an attorney double check that, and they thought that that was accurate, but I can't speak to the different foundational bits. I'm just not that informed on that. So I hope that helps a little bit. Certainly feel free to call us if you want to discuss it more. And I think that brings us up to date then with the questions, right?
Yep, you're good.
Okay.
Okay, so now I'm going to talk about the Minnesota criminal justice process. This is going to be a snapshot of the criminal justice process. We know that it can take months or even years from the beginning to the end to go through all this. So let's say an assault had happened and a crime has occurred and a 911 call has been made, or there is a request for assistance at the local police department. Law enforcement will respond to the call and investigate the report incidents to determine whether what happened could be considered a crime, and if there is enough evidence to present the case to the county attorney's office for possible prosecution. It's good to know that in Minnesota, some rural counties don't have a city prosecutor, and the county attorney's office will be the one handling all the criminal cases, misdemeanors, gross misdemeanors, and felonies. If the city or town has a city attorney's office, they will be the one handling petty misdemeanors, and maybe some gross misdemeanors, depending on the city. Prosecutors in the adult criminal division are going to review the police file to determine if there is enough evidence to charge a crime. The office is going to file the charges when there's enough believable evidence that a conviction in trial is going to be likely. If there is not enough evidence, the prosecutor would either refer the case back to law enforcement to do more investigation on it, or will not file charges at all. When there is enough evidence to charge a crime, the prosecutor will issue something called a criminal complaint. A complaint is a formal written statement of the charges against the defendant. It has a statement of facts that are showing that there is probable cause to believe the offense was committed and the person was charged. The person that is being charged committed it. The complaint must also include the name of the crime, the statute number of the law that was broken, and the maximum penalty of the crime. The complaint is first signed under oath by the investigating officer. That person sent it to the prosecutor. The prosecutor approved the complaint by signing it again, send it to the judge. The judge then determines if the complaint has shown probable cause to support the criminal charges and prove it by signing the complaint. There are different types of criminal complaints. One is a detention complaint, and is issued when the defendant is already in custody. So if someone is arrested without a warrant, prosecutors have 36 hours to either charge the case or release the person. If the defendant is not in custody, then they're gonna either issue a warrant or a summons. A warrant, like we know, is a court order in the complaint allowing police officers to arrest and bring to jail the defendant before the first appearance. And a summons is a court order in the complaint that requires that the defendant appear in court on a specific date. So they will send a letter in the mail saying you need to come to court for this hearing at this day at this time. If a defendant is sitting in jail after an arrest, an arraignment or first court appearance must generally taking place within 48 hours of the arrest. For out of custody defendants, an arraignment might not be scheduled for days or weeks. A defendant's first appearance in court is going to be informed of the charges, is going to be informed of their rights, including the right to an attorney. So if the defendant cannot afford to pay an attorney, the court will appoint a public defender to represent them. They may enter a plea, usually guilty or not guilty. If the offender entered a guilty plea, that happens sometimes in very minor crimes, typically the judge will want to know what was done to make the person guilty of the offense. And most of the time, the judge will do the sentencing the same day. If there is not guilty plea, that we see a lot, the judge also sets bail and the conditions of release. I'm going to talk a little bit more about bail later on, but bail is money that the defendant must pay to make sure they appear at trial. In some cases, a defendant may be released without bail, and it's called release on your own recognizances. So sometimes we see it on the criminal record like ROR or OR. Courts usually release defendants on their own recognizance only in minor criminal cases or when the defendant has a minimal record or minimal criminal offenses, if any. They have to have a permanent address. Sometimes they ask that they have a place of employment. The defendant has to sign an agreement that they will appear in court as required. Conditions of release sometimes we include, no contact with the victims or the witnesses, and they're gonna come as no contact order or a domestic assault no contact order. They may be part of the conditions for this person to be released from jail. Sometimes they put geographic restrictions, like they can't leave the state of Minnesota. Sometimes we can see that they say random drug testing or other conditions the judge considers appropriate, like supervised pretrial release. All defendants who are released are ordered to attend their court appearances and remain law-abiding by not committing any new crimes. So we see that everywhere. What is supervised pretrial release? So this will be like an alternative to setting a bond or other conditions of release. The court can place a defendant in a supervised release program while his case is pending. This is known as pretrial supervision and is similar to being on probation while your case is pending. The defendant will be required to report to a probation or other supervising officer and to comply with all the conditions that officer has set up for them. Community corrections provide monitoring before the trial, and it could include complying with the no contact orders, remaining law abiding, maintaining current contact information, address, also completing random UA testing, chemical health evaluations. And sometimes if a treatment of certain kind is ordered, they also check how the progress is been going on with the treatment. Note that if bond or bail is ordered, they have to be posted prior to program intake and release from jail. After this arraignment or first appearance comes the omnibus hearing or pre-trial conference. And it's normally the first opportunity where the prosecutor and the defense attorney determine whether the case can be resolved without a trial, or if not, they have to go to trial. There are several possible resolutions without a trial. One is that the defendant pled guilty as charged. So he admits or she admits that he's guilty to the charge offense, and the case then moves on to a sentencing date. They can plead guilty to an amended charge. Sometimes we see that too, that domestic assault charges go down to disorderly conduct. So the defendant admits guilt to a different charge than the original one, and the case also moved to sentencing. Sometimes we have counties that have diversion programs. Adult diversion programs refer to this offender. They send them to either social services, chemical dependency, or mental health resources. It could be also like drug court or DV court. The eligibility and requirements depend on the county. Some county attorneys don't have any programs that will accept someone facing assault charges or felonies, and others do. The prosecutor may offer this to allow the defendant to avoid a conviction by completing a diversion program instead of pleading guilty and being convicted at trial. And the last thing that can happen is the dismissal of the case and the defendant goes free. Is the defendant pled not guilty or the case cannot otherwise be resolved, a judge will decide if there is enough probable cause for the case to proceed to trial. And if there is, a trial date will be set. What we need to know about trial, it's that there's two types of trial. We probably heard a jury trial and a court trial. In a jury trial, the jury makes the decision about whether the government can prove the defendant is guilty beyond a reasonable doubt. The jury is required to give the defendant the presumption of innocence, and the presumption remains until all jurors agree that the defendant is guilty. In a misdemeanor or a gross misdemeanor case, there are 6 jurors. In a felony case, they are 12. The defendant can also waive his right to a jury and have a court trial. In a court trial, the judge listens to the evidence and decides if the government has met its burden of proof. So the big difference between the two is a court trial, and between a court trial and a jury trial is in the court trial, there's only one person listening to the whole thing. In a jury trial, there's either 6 of 12 people. After this, what comes the end is the sentencing. And it could be a minor process in misdemeanors and in some gross misdemeanors, and it could be really complicated process in some gross misdemeanors and some felonies. In most misdemeanors, or in the sentencing can generally take place right after a guilty plea, and sometimes even after a jury verdict. In a felony, the court will ask for the PSI, the pre-sentence investigation, and is prepared by probation and given to the court and the attorneys after a meeting with the defendant. This PSI will summarize the defendant's criminal history, the work history, the educational history, as well as any challenges the defendant faced, such as mental health issues, chemical dependency issues. It also makes recommendations to the court about what sentence the court should impose, but these recommendations are not mandatory, and the court ultimately has the discretion to sentence as it sees fit with certain limits. At the sentencing hearing, the prosecutors and the defense attorneys present their positions. They all talk about why they think the person is guilty or not guilty with regard to what they believe is an appropriate sentence. Under Minnesota law, the victim is entitled to tell the court through the victim impact statement how the crime affected them. Community members can also demonstrate the indirect impact of the crime on the larger community through the community impact statement. The prosecution presents the impact statement to the court, and we know that sometimes victims they don't want to stand up in court and give their statement, but they can request that either the victim advocate read the statement on their behalf, or the prosecutor can read that statement, or even sometimes they want the judge to read it not loud, that they can read it quietly. So it's all about how the victim wants to proceed with this. Now we're going to talk about the DANCOs. We're going to go back a little bit to the conditions of release. And at the end, we're going to talk about bail in a little more depth. So where are those? We are all familiar with the DANCOs. They stand for Domestic Violence No Contact Order. A DANCO generally is issued by a judge in a domestic violence case against the defendant. It is issued on a pre-trial or probationary basis, and it prohibits the defendant from contacting the alleged victim or victims if children are in the household. Sometimes we see children in the DANCOs, regardless of the circumstances surrounding the charges, until the case is dismissed or the defendant is sentenced. The judge also may issue a DANCO as a term of probation. So sometimes we see that the case have been sentenced and they still keep the DANCO in place until that person finishes the years of probation that they set up. That means that the defendant cannot have any contact with the victim while they are on probation. If they violate the order, it could void their probation and they could be going to jail again. The judge will lay out the terms of the no contact order, which may include any or all of the following: no face-to-face contact, no conversations or interactions in person, no electronic contact, no emails, no texts, no phone calls, no indirect communications, like using a third party to send messages to the victim. They have to stay a certain number of feet away from the victim. So they have to avoid their places of where the victim lives, where they work, even sometimes homes of their friends or family members. It's important to know that a domestic abuse no contact order is independent of any condition of pretrial release or probation. I'm going to talk a little bit about that. It's a violation of the DANCO will not be a violation of the condition of pretrial release. Instead, it's going to be a new crime. The prosecutor can charge a new criminal offense with a new offense day, a new violation, a new crime that was committed because of a violation of the DENCO. That doesn't happen with no contact orders. No contact orders, if you violate the no contact order without the D in the front, it could be a violation of the condition. But if you violate the DENCO, it's a new crime. We need to let our victims know, and I know they know that there's not going to be anybody following them around to see if they are talking to the abuser or if the abuser is looking at them or calling them. I mean, the victim has to make the report, but they have to be careful too, because I have a story about a client that I was working with. She was a victim of domestic assault. There was a DENCO in place. And she called me one time crying on the phone saying, he's in jail again, he's in jail again. And I'm like, what happened? And she's like, it's my fault, I did it. And I said, but what happened? Well, it seems like he was the person that was driving her to work every single day. They were husband and wife. So when this happened and he had to move out of the house, she called him and said, hey, this is all your fault, and you have to still driving me to work because I don't have a way to go to work and I don't want to lose my place of employment because of you. The defendant told her, I can't do it. Remember, I have a no control order in place, a DENCO. I cannot see you. I cannot do this. I cannot. Well, she insisted, and he decided to go and pick her up and take her to work. So what happened? On the way to go to work, he decided to stop at the gas station because they didn't have enough gas. And in the gas station, there was the same police officer that arrested him the first time, was also putting gas on the same place. So he went from the gas station to jail again. So we need to let our clients know that they're going to be charged with a new crime if they do violate the order. So I know sometimes they need to talk to them because kids or whatever, but it's a lot easier if they try to find a way to dismiss the DENCO instead of making the guy violate the DENCO. One thing that we need to know is DENCOs are not mandatory as part of the conditions of release. It is the court's decision. Sometimes a prosecutor won't request one, maybe because they talk to the victim and the victim say, I don't want to have that, but the judge will see it differently and the judge will put the DENCO. Or sometimes the prosecutor requests the DENCO, but the defense attorney argues against it for some reason. Usually, I don't know, because they talked to the defendant and they found out some reason to not have a DENCO. Or even because the victim was there in court and the victim told the judge that they don't want it. So as advocates, we need to know how aggressive the prosecutors and judges of our counties are protecting the victims of domestic abuse from future violence and holding abusers accountable of their behavior. I know by my own experience as a legal advocate, when I was working as a legal advocate, that in some counties, a DENCO is always a condition of release. It doesn't matter what. In others, it's not. In others, if the victim doesn't want it, they don't put it. It is important to know that a person charged with a domestic crime, even if they post a higher unconditional bail with the court, they still are going to be subject to the DENCO. So when we talk about bail, we're going to talk about that. Another thing about DENCOs is that we all get those calls from victim survivors that we have been working with, where the first thing they say when we answer the phone is, I want to drop the DENCO. Well, only the judge can remove the DENCO. It is a difficult process, and there are many reasons why a victim may want a DENCO removed. The victim may not view the offense as serious enough. The victim wants to start couples counseling. Sometimes moving the defendant out of the family home will disrupt their lives. For example, sometimes they both work different shifts. So one of them stay with the kids while the other one is working. Other times the victim doesn't work and cannot support the family by itself. The couple may have children together and need to communicate and coordinate parenting matters, or the victim wants to recount their story, claiming that they lied, or their story was not how it happened. All try to save the defendant, like we said before. Not the best way to ask for a cancellation of the DENCO. Sometimes I've heard also, I had a case where the defendant was really sick. I mean, he was diagnosed with meningitis. He was really, really sick. And they thought that the person was going to die. And the victim was trying to dismiss the DENCO, and it never happened. So it's really hard to get off, at least in the county where I was working. I used to work as a legal advocate in a county where the victims had to come to our domestic violence program and do what was called a safety planning class if they wanted to ask the court for a modification or a dismissal of the order. This class was mandatory. And I remember that sometimes the victims will be calling for an appointment the same day the defendant got the conditions of release. This is why it's very important. The sooner we get in contact with the victim, the better the outcome. What we can do, we need to get informed of how our counties handle these cases when somebody wants to dismiss a no contact order, a DENCO, or when somebody wants to modify the DENCO. What the victim needs to do to make the request to the judge handling the case. The victim may have to write a letter to the judge asking for the modification or the dismissal of the DENCO, explaining why they feel the DENCO should be canceled or modified and why they feel safe now. They may need to talk to the victim's advocate from the county attorney's office to relay their wishes to the prosecutor. They may need to meet with one of us, legal advocates of the domestic violence program in the area, and do the safety plan. Each county handles this in a different way, and we need to know how to help these victims when they want to do this kind of thing. The other thing is that I wanted to talk about is about a bail hearing. Before the bail hearing, the court probation office may conduct a pretrial release interview of the defendant. This is a worksheet that the person have to fill out. And then after that, there will be a number score. In the pretrial release score is intended to help in determining whether to release a defendant or assign bail and or conditions. They take in consideration factors relating to the likelihood of making future court appearance and also public safety. They also take in consideration if the defendant has a place of employment or going to school, if they have pending cases, if they have any current problems with the use of alcohol or drugs. They take in consideration if there was a lethality assessment conducted, so what it says. And we know that sometimes the advocate does the lethality assessment, sometimes law enforcement does it. If they have previous failure to appear to court, if they have bench warrants, if they have any criminal convictions, all of this is taken in place. At the bail hearing, the judge can either, one, order, set an amount of bail that the defendant must post to be released, order the defendant to be released without any conditions, that is on his own recognizances, or authorize the release with specific conditions, including supervision or other restrictions on the person's actions. Release on bail on bond, when the judge requires that a defendant post bond or bail, the defendant must post the money with the court in order to be released, pending the completion of the case. For example, if the bond is cash, let's see, $10,000, then the defendant or a third person on their behalf must post that amount with the court. Once the case is completed and satisfies everybody, the judge requirements, the money is refunded, except for any fees that the court requires. The defendant can also have a contract with a bondsman. We have heard about them, to deposit a percentage of the bond amount with the court, with a contract that the bondsman will pay the balance of the bond if the defendant does not appear for court and cannot be located. So the defendant must pay the bondsman a non-refundable portion of the bond, generally is like 10%, and provide a collateral. This will be like a deed to a home, a real estate, or a cosigner, or both, to guarantee his appearance. If the defendant disappears and the bondsman is required to pay the bond to the court, then they're going to collect the money from the consignor, or they're going to take possessions of the collateral. If the person cannot afford to pay the bail amount, we know what happened. They remain in jail until the trial. Everybody have the right to bail without conditions. That is called unconditional bail. It's a right under the Minnesota Constitution. At the bail hearing, judges order 2 bail amounts. They should do the unconditional bail and bail with conditions. Normally, the amount of money a judge requires for the unconditional bail is higher. And this is to create a financial incentive for the defendant to accept the conditions for conditional bail. We know that sometimes they do the unconditional bail, so they pay the higher amount. But as I said before, we need to know that the DENCO, it goes with it. So they can not have any conditions, but the DENCO is in place. So I think that's all I have for bail.
Great.
And now, Maddie, welcome.
So now we're going to fast forward to a topic that comes further along in the process, but it's a priority to discuss because it really is how the majority of these criminal matters get resolved, and that is by plea deal, which is a negotiated agreement between the defendant and the prosecution. And a plea deal can be the prosecutor's offering to reduce the charges to something less serious in exchange for a guilty plea, or to dropping some charges in exchange for a guilty plea on others. They can negotiate around a sentence, or they can offer stays of adjudication to give the offender a chance to have the charge removed from their record if they comply with the sentence. Most of the charges we're talking about do resolve in this way and never actually make it to the trial stage. And as we know, this is really upsetting to a lot of victim survivors because it feels like the offender isn't being held accountable. And so it's helpful to sort of understand the reasons why. And as we've already mentioned, one of them is that our criminal justice system is just very overloaded. So unfortunately, that creates an incentive to get resolutions on criminal matters as soon as possible. It also takes just an enormous amount of resources to hold a trial, and to have them on every matter that goes through the system would just mean that they got scheduled out for years. And so, you know, of course, trials are also just a big gamble. You know, the person could also always just walk away without any consequences. So plea deals are a strategy for getting some type of result, some type of programming or probation, incarceration, or conviction on a charge so that the next similar offense can be enhanced, like we discussed. But these basic realities are understandably not going to be enough for the victim of a crime. And the specific reasonings for plea deals are very case specific, of course. And they're not usually something that a community advocate can speak to with much nuance. And so if you're working with someone who's really upset that this is happening, a community advocate's role might be to arrange and sit in on a meeting between them and the prosecutor's office, because they're the ones who are going to be able to explain those details. And you may also consider that prosecutors are thinking about what their plea deal options might be when they're assessing the evidence and the charges law enforcement sends over. So what they end up charging could be part of this larger strategy. But victim survivors are certainly not going to be thinking about that or tuned into that strategy. And I think often it can look like the harm that's being done to them just isn't being taken very seriously. So as advocates, we can be helpful in sort of setting expectations and explaining some of these big picture things, while also, you know, acknowledging that the system is really imperfect. And this is maybe a good place to bring up that we know that many, if not most, victim survivors don't stay engaged all the way through the process. You know, it's drawn out, it's invalidating, it rarely feels like adequate justice. And that is really a conundrum because their continued involvement has an impact on the outcomes of these cases. So if advocates can help them have some awareness of what this process is going to be like and offer that additional support, it may be the thing that gets them through to the point of writing that victim impact statement or finding the willingness to report violations and things like that. Okay, so obviously this process is very, very complicated. And while advocates community advocates can and should try to assist their clients throughout it if they have the capacity. There does exist a position within most county attorneys' offices and some city prosecutors' offices to really be a guide and a translator of that court process for them. And that, of course, is the victim witness liaison or advocate. And they work with victims in criminal matters that their offices are prosecuting exclusively. One of their primary functions is to ensure that the victim's rights are being upheld throughout the criminal process. And I'm going to say more about the Minnesota Victims' Rights Statute in just a bit, but a lot of what you see these positions doing are detailed and laid out in that statute. So providing victim notifications, things like updating on the criminal matter around bail, supervised release, scheduling, explaining plea deals, explaining terms of probation and other sentences. They're also the main bridge between the victim and the prosecutor. And so they'll ask for victim input and then pass that on. They may do something like help the victim quantify and put in a request for restitution that the prosecutor is then going to push for. It might even be explaining prosecutorial strategy or charging decisions to the victim. And they might do more general advocacy too. So helping with filling out applications for reparations or making referrals. But there is a key difference between this type of advocate and a community advocate, which is that a victim witness liaison is not a domestic abuse advocate as defined by statute. And therefore they don't have a duty to keep victim statements or information confidential, which is something that most victim survivors don't know. But these folks are a part of the prosecutorial operation, and they have a legal duty to share additional evidence that comes to light with the prosecutors. And then the prosecutors have a legal duty to share that evidence with the defendant and their attorney. And this evidence can be used without the victim's consent. And this isn't to discourage communication whatsoever. They are a great resource, but rather to point out that this position has a similar title to community advocate, but does not have that confidentiality requirement. And so it's just something to keep in mind when you're communicating with them and you're encouraging them to your client to communicate with them. So like I said, a lot of the role of that position is about initiating and upholding the tenets of the Victims' Rights Statute. Hopefully most of you are aware that in Minnesota this statute exists, but what it does is it lays out an extensive list of those rights. And it addresses things like the prosecutor's responsibility to make reasonable good faith efforts to update the victim on things like if they're declining to prosecute or on outcomes of the criminal matter. And then it lays out reasonable good faith efforts to seek victim input, the right of the victim to seek restitution, provide the court with a victim impact statement. But the thing to keep in mind about this statute is that there isn't any enforcement mechanism within it. So it's helpful to think of it more as a tool for you to use. So something to reference if you see these rights being ignored. So again, that's going to come back to your relationships with your prosecutor's office and whether or not you're able to have a productive conversation around it. And prosecutors' offices should want to be in compliance with this statute. So if they're not, it might just be appropriate to reach out, point out the parts that maybe aren't being met and seeing if there's a way to assist them in getting there. All right, so we're nearing the end, and this is the last thing that we're going to touch on today, which is the importance of using the victim-centered approach when providing advocacy. And I'll admit that it took me a long time doing this work to realize that this isn't just a self-explanatory expression. It really is an important framework for working with victim survivors that presents some specific philosophy. And applying its elements is something that is required by most funders of this work. And most of the things in this we probably already do without needing any reminders or direction. So things like being trauma-informed, believing our clients' experiences by default. But there are certain points that are worth bringing up in a presentation on this topic, because one of the key objectives of the victim-centered approach is to minimize the re-traumatization that we know is associated with victims having to navigate the criminal justice process. So one of these points is advocating for what the person wants, even if it changes, and even if you as an advocate don't agree with it. And I think that an area that this comes up the most frequently is when we're working with someone who wants to dismiss a DANCO. You know, advocates may see this action as dangerous or naive, but it doesn't mean that we get to insert that opinion into how we're advocating. You know, it might be acceptable to tell the person we're working with that we're worried about their safety if they do that, or to discuss how domestic abuse dynamics may be influencing that decision, but we should not be advocating against their choices. And a lot of times, you know, we might be in the position to do just that. You know, we might be tasked with helping a client fill out a DANCO dismissal request, signing off that we safety planned, and then giving that to the prosecutor's office. And so there might be a temptation there to insert your view into this process. You know, maybe telling the prosecutors that you don't agree with it. But doing that, A, has implications around confidentiality, but B, it makes the assumption that we know better than our clients do about their own lives. And that runs very contrary to the spirit of the victim-centered approach, which requires letting the individual make their own decisions and adopting, to the best of our ability, a practice of non-judgment about them. Because a big objective of this approach is to restore the power and control and personal autonomy that has been taken away by the abuser. Another example of where this might come up is in the information and options that we're providing. So if we are intentionally gatekeeping certain options because it's our opinion that they're bad for our client, we're going against this approach. You know, it is our responsibility to provide accurate information and options, regardless of what we think the client should do. And we can and should share details of common negative consequences of certain options that we're aware of, but it's not our role to give advice. So this approach has different implications for the different roles throughout the criminal justice system, but advocacy in particular is about promoting victim survivor perspectives. And so we just have to be really vigilant about doing that. And, you know, it requires us to practice an awareness of when we have instincts that run contrary to doing it. So that is all that we have for you today. Whoops. And did I stop screen sharing there? Let me see if I can get it back so that you can have our contact info. But we have about 10 minutes left here. So if anyone has any questions, you can go ahead and type them in the chat, and we will do our best to get them answered.
I don't see any questions at the moment.
All right, well, we'll give it just a moment here in case anybody is typing. But otherwise, you will have about 10 minutes of your life back.
Thank you very much for being here today. And I hope you all have a happy holidays, and we'll see you again in January.